I could have.
Okay, today we're going to discuss about key features of immigration control, and then we'll discuss at second stage making a valid application, and thereafter we're going to discuss preparing an application, and then we'll discuss a conclusion, and within making valid application we'll discuss number of other areas, for instance entry clearance, leave to remain, application time, valid versus invalid application, fees and exemption, blah blah blah. So this is the whole brief table of content. Uh, After explaining one topic, I'll give you ample time duration to pose any question. It's important for you to have a pen and paper with you for making your note. Obviously, immigration law is new for some people, although some people have some background related to immigration law. However, for those people who are new in immigration law, please write down on your paper any question which you're going to raise while giving this lecture. So you can pose the question whenever I'm going to ask you to pose any question. So let's take a start. The key features of immigration control. So there are, however, there are some exemptions. What are those exemptions? As I told you, the people would need some sort of a visa or permission to enter or entry into the UK. But there are certain exemptions. We have taken these certain exemptions from Section 1 of the Immigration Act. Now, the second exemption is those people who are part of diplomatic staff and officials, and in limited circumstances, the crew members of ship and aircraft. So this is the whole back general rule. All people would need a permission in order to enter in the UK, but there are certain exemptions. I explained you there are three exemptions. So I hope you have understood now the whole concept of the key concept which has been explained under Section 1 of the Immigration Act 1971 about the categories which are exempted from the immigration control. Now, let's move forward about the structure of the Home Office. If we discuss about the departments of Home Office, that how many, then within the Home Office, how many departments we have got, and what is basically the structure of the Home Office. We basically divide the structure of the Home Office into three categories. First of all, UK Visa and Immigration Control. It is called UKVI. UKVI is basically responsible for visa, asylum, and settlement decisions. Then the second important department or team is called Immigration Enforcement. Immigration Enforcement team is responsible for compliance, removals, and enforcement action against immigration breaches. You might have heard in the media that the immigration enforcement team have caught some people while working illegally uh, on takeaway, they were illegally working on, you know, any grocery store, and they have caught those people and they have issued removal directions against those people, blah blah blah. So basically, though whatever was the news, basically that was immigration enforcement team, which was involved. Obviously, in the news, we do not normally understand or hear that what part of immigration team was involved in enforcement team. However, as I told you, the immigration enforcement team normally involves if there is an issue of enforcement. Then we have the third structure or the third category, which is called UK Border Force. UK Border Force is basically responsible for frontline border control, including immigration checks at ports and airports. So these are the three important structures of the Home Office, or these important three teams of the Home Office. I hope all of you understood it very properly. Let's move types of visas and permission. As I told you that all people would need a permission or a visa for the purpose of entry into the UK, and it's a general rule according to Immigration Act 1971. However, there were certain exemptions. Now we are basically dividing the type of visas and permission into four categories. The first category is called visit visa. The second category is called family visa. Then we have worker, business, and investor visa. And the fourth category is called student visa. I'll not explain the further in regards to these visas. However, in our previous lecture, if you go on our YouTube channel, you're gonna find I have explained in very detail about the nitty-gritty or about in and out about these visa categories, then how to apply and when to apply. As far as concerned about this lecture, I'll give you, uh, once we have finished this lecture, we'll give you a recording. And on top of that, we're going to provide you PowerPoint lectures through the WhatsApp group. And thereafter, you'll be able to find, further understand. However, for the purpose of today's lecture, I'll touch a bit about each of these categories. So the visit visa is basically a temporary or a short-term visa, and it is not in this route does not go toward the settlement. Uh, we normally apply for 6 month visa, 2 years visas, and sometime we apply for 5 years visas. However, an individual is required to leave the UK within the 6 month times, no matter the 2 years or up to 5 years. So this is the whole explanation about visit visa. The second one is called family visa. Family visa is basically a thought visa, which normally considers a long-term route. And this category normally leads to the settlement. For instance, a family person visa, a family visa or spouse visa, which an individual has applied on the basis of sponsor who is a British national and settled in the UK. Basically, this is an example of family visa. This is the sole example I have explained you, or there are other examples as well. However, for the purpose of today's lecture, I'll just focus up to the extent of explanation which I have given you. Then the third category is called worker, business, and investor visas. Some of these are some long-term routes for employment. Some of these routes normally leads toward the settlement, but not all of them. Then a student visa, it's a temporary visa for individuals. This visa is for those people who normally come in the UK for the purpose of their studies. For instance, if you wanted to come for the purpose of LLM or Bar Law or for any other course like PhD, you're gonna straight away go to student visa. Student visa does not directly lead to settlement. However, after studying 1 year in this country, you'll be able to apply straight away for 2 years work permit, and thereafter, after 2 years work permit, straight you can straight away switch into skilled immigration, and after spending skilled immigration, you can straight away apply for naturalization. So this is the whole process, and I have explained you in details about four main categories, not in that much detail, but up to the extent of this lecture, which I already explained you in detail. Now, let's move forward to the next topic, which is called permission to travel, enter, and stay. Um, we have already discussed a bit about Section 1 of the Immigration Act 1971. Basically, this section uh, discuss uh, the individual who are not exempt from UK immigration control. What are those individuals who are not exempt from the immigration control? Those people who require entry into the UK, who are residents in the UK, and who needs departure, come and go into the UK, and the people who have right to live, work, and set and not permanently settle in the UK. So these people would always are subject to immigration control. However, those people who have a right of an abode and they may enter and travel in the UK, how they're going to enter and travel in the UK who have right of an abode, they can stay away, enter into UK by using their British passport. They can enter into the UK by using any foreign passport, but that passport must have a right of an abode stamp on it, or an individual who is holding a certificate of entitlement as in right from a board, they can enter even on that certificate. So this was the whole crux. In summary, anyone who does not have right of an abode would leave permission to enter, remain, or uh, live in the UK. And on top of that, let me further add you that those people who do not have right of an abode, who are not British national, they are not allowed to use the uh, public funds. Those people who have right of an abode or who are British national, they are allowed all the public funds. But those people who are not on settlement, who are on other categories, four categories, which I already explained you, they are not entitled to use the public funds. So these were the whole details about so far. Before we move forward about the E category, uh, if there's any question you can point at this stage so we can move forward. I can give you a small time break and thereafter we're going to move forward. Please, any question so far? Hello?
Can you please explain right off about a little bit?
No problem. Who is speaking, please?
It's Wafa.
Wafa. Okay, let me explain you. As I told you, Wafa, all people would need to enter in the UK, right? But those people who have right of an abode, right of an abode is like a passport. Those people who have right of an abode, they are exempt to enter in the UK. For instance, if you are a national of Dubai, obviously you are a national of Dubai, then you can enter into Dubai. Or you have a settled status in Dubai, then you can enter. Then all people can enter. There is no restriction at all. But these are exempt categories. They don't need any. In a very same way, all people need a visa, but those people who have right of an abode, they don't need any permission. Who are obviously right of an abode are with those people who are British national or right of an abode can be stamped on any foreign passport. They can enter, or right of an abode can be in the form of certificate. Nowadays, the Home Office does not issue any certificate of right of an abode, but some people still have right of an abode on the certificates even. So they can enter in the UK through their right of an abode because they are entitled, they are full-fledged national of this country with all of their rights. Apart from them, as I already explained to you about four categories, any person who wanted to enter into the UK, they need to get those four categories. They need to fold themselves into four categories, and thereafter they can enter themselves in the UK. This is the whole crux of right of an import. I hope I explained you in detail, Wafa. I hope you understood it now.
Yes, sir.
Wonderful. Any further question from anyone, please?
Yes, sir. There is a question from my side. My name is Yumna. I wanna ask that you
Mhm.
told us that we have to come back from UK after every 6 months, no matter the time period we are there for under visit visa, right?
Mhm.
So
Yes,
so
Yumna,
do
you
we
are
need
100% right.
so we have to come back after every 6 months, even if we are there for like 5 year visit visa.
No, no, no. Let me explain you. Within 6 months time or 2 years or 5 years time, if you are go even 5 times, there's no restriction at all. But as I told you, it's a visit visa. The purpose of visit visa is, there are different purposes of visit visa, but you have to come back. You are not entitled to stay on permanent basis, no matter if you have a 6 month visa, you have 2 months, 2 years visa, or 5 years visa. I can understand the number of students who are new, and it's a new terminology for all of you. I'm quite confident after 2 or 3 lectures, you'll have proper grip of each and everything. Then you'll have fewer questions. So uh, I'm trying to explain you, but it's entirely a new lecture for you. Therefore, it's a bit difficult for you to digest at this. The passage of time, I'm sure and I'm positive about it. I hope I explained you a bit about visit visa and how they can come. They are required to come and go. They are not allowed to stay more than 6 months. Even they have 2 years or 5 years stamp on their passport. This is the whole crux of visit visa. Visit visa is not subject to convertible. We can't convert visit visa into any categories. There are some exceptions which I explained to you in detail. I hope I explained you. So let's move forward instead of focusing here. I'll take further questions once we are on track. Is that okay for you guys?
Yes, sir.
Okay, let's move forward. Each of these category about the categories entry clearance. Basically, entry clearance is a form of immigration control that is granted before an individual travel to the UK. So most of the people who wish to enter in the UK are required to get entry clearance or visa. Visa or entry clearance, it's basically one and the same time. They normally submit their applications to their countries of nationality or at that place where they have got their country of residence. For instance, if A is residing or doing a job in UAE, Saudi Arabia, or Qatar on temporary basis, and they have got residency or visa of that country, obviously they wouldn't go back to the home country in Pakistan. They can straight away apply entry clearance from their country of residency. However, they need to satisfy to the Home Office that they about all the parameters, whatever are required to apply the visa from the home country and from that country on which they have got entry clearance. So this is the background of entry clearance. And entry clearance visas are basically those visas where an individual can apply from the country of residency or from the countries where they are national. So this is the whole crux. The usual point of entry into the UK is an airport, seaport, or some your terminals, which are called your terminals. And on the entry clearance points, individual normally face the Home Office, border permissions people, and they normally foresee or check the visas. They have full-fledged power to cancel any entry clearance on the point of entry. So this is the whole crux of entry clearance. And Visit visas applications are generally divided into two categories: visa national and non-visa nationals. What are non-visa nationals? Non-visa nationals are those people who normally do not need a visa in order to enter into UK. For instance, there are some EU countries who have signed protocol, the Home Office, and they normally get their visas on the port of arrival on on the airport. They don't need any entry clearance in advance. On the other side, there are some countries, there are not some countries, most of the countries, and they would need entry clearance or visa and before entry into the UK. So this is the whole crux of about entry clearance. Let's move forward to the second category, which is called leave to enter, leave to remain, and limited leave. So, are you writing with yourself? Are you taking notes with yourself? If you have any question or in for later stage, are you writing notes with yourself? Can you please confirm with me, please?
Yes, sir.
Yes, sir.
There we are.
Wonderful. That's wonderful. Leave to enter, leave to remain, and limited leave. Uh, there's no substantive distinction between leave and permission to enter or leave to remain and permission to stay. Don't confuse yourself with these terminologies. Like we have entry clearance or visa, they are substitutive words. We normally use these words uh, in different timings and in different scenarios. So, in a very same way, these are substitutive words. We have no substantive distinction in all of these words, right? So, you need to understand the main difference lies in the location where that permission is granted, either at the point of entry to the UK, for instance, entry into the seaport, Eurostar terminals, Heathrow, Dover, blah, 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 right? The term leave to remain is used to describe both the period when the individual is lawfully permitted to stay in the UK. So you need to understand what does leave to remain mean. Can you write down with yourself? Leave to remain. We basically apply leave to remain within the UK. For instance, a person who has entered into the UK on the family visa and he was granted a visa for 2.5 years, and after finishing limited leave to remain, he would apply for another extension. This is the example of leave to remain. The next category is indefinite leave to remain. What is indefinite leave to remain? If anyone has got an idea who attended our previous lecture, any idea, please just share with me. Any idea what is indefinite leave to remain? I'm positive Adnan gonna tell us because he attended a few lectures of us. Adnan, are you with me now? Hello? No one can explain at this stage. Can you hear me, please? Hello?
Yes, sir, we can hear you.
Wonderful. Tanzila, let's move forward now. Indefinite leave to remain. I hope so. Adnan is not with us. Anyways, let's move forward as no one is in a position. Most of the people are attending this lecture first time. So obviously they are not in a position to explain at this stage. So let me explain you what is indefinite leave to remain. Indefinite leave to remain is basically a form of immigration status without a time limit, usually without any conditions attached. People who have got indefinite leave to remain are generally eligible to apply public funds. Let me explain you. After indefinite leave to remain, people normally apply for naturalization and thereafter they apply for British passport. So basically, indefinite leave to remain is a stage before naturalization. So ILR, we normally use ILR for indefinite leave to remain, and we normally use settled person status as well for indefinite leave to remain. Under the former EEA former framework, EEA nationals and their family members could acquire permanent residence, which was basically a similar way of indefinite leave to remain. Obviously, England is no more a part of EU. Previously, we had England was part of EU, and those people who were EU national, they would stay in this country up to 5 years, and thereafter they would apply for permanent residency or settled status. Their settled status had straight away an equivalency of indefinite leave to remain. And on top of that, it's important for you to understand that indefinite leave does not expire. However, in certain circumstances, an individual can lose indefinite leave to remain if an individual is absent for 2 years from outside the UK. Then he gonna lose the indefinite leave to remain. If an individual with indefinite leave to remain stayed outside from the UK for 2 years, then he or she would apply for returning residence. And the Home Office can refuse returning residence application. They need to show that why they're applying returning residence, and they have to show that they have sufficient ties in the UK in order to apply for returning residence. And on top of that, as I told you, that some people on the basis of EU route, they can again apply for settled status. But those people who have got settled status, they are allowed to stay outside from the UK for 5 years, not for 2 years. I hope you understood indefinite leave to remain.
Yes, sir.
Wonderful. Let me move. Okay. Any questions so far about these 2 or 3 topics? Please raise any question if you have got any question, then we can move forward. Any confusion? I'm going a bit slow today because there are lots of people who are new in this whole session. Therefore, I'm giving you, after explaining 1 or 2 topic, I'm giving you an opportunity to raise any question. So we'll make it short today. Today's session is basically the base of the whole of course. I can understand it's entirely new for you and it's difficult for you to digest the whole new topics, the whole new terminologies. Therefore, I'm giving you an opportunity to raise any question at this stage. Any question, Tanzila. I'll remember your names with a passage of time, but not at this stage. Wafa, then Shanza, Zumar. Any question at this stage, please pose any question.
So who are the people who get the right of indefinite leave to remain? I had connectivity issues, so that's why I missed that point.
Let me explain you. There are certain rules to get indefinite leave to remain. For you cannot get, or individual cannot get indefinite leave to remain straight away. For instance, a person who has lived in this country up to 5 years and that person was on a spouse visa, they're gonna get indefinite leave to remain. In a very same way, for those people who are legal in this country, I mean, a student visa, combine skilled immigration, combine any other legal category, they can get indefinite leave to remain after 10 years. Those people who are on skilled immigration program, nowadays there are lots of people who are on skilled immigration categories, they're gonna get those people who are illegal in this country, they're gonna get indefinite after 20 years. So there is not a single answer that how there is not a single category. There are a number of categories through an individual can get indefinite leave to remain, and you're gonna learn with the passage of time. And after indefinite naturalization. So indefinite remain is the pre-stage of a naturalization, and after naturalization, you can straight away apply for a British passport with the whole rights, with no condition at all. So this is indefinitely to remain. Is it clear to everyone now?
Right, so
Sir, I have
So,
one query.
Who is speaking,
Sir,
please?
Sir Tansila is here. Sir, I
Yes,
want to
Tanzila.
ask one question.
Yeah, go ahead,
Sir,
Tanzila.
Sir, if a person who has like granted the asylum there, so sir, once they are going to be the legitimate citizen of the UK, so then will they be eligible to get the um, will they be eligible to give the leave to remain?
Let me explain you. You are mixing up the whole immigration law, Tanzila. Let me explain you. As far as concerned about asylum visa is normally granted for 2.5 year, or they have to complete 5 years in this country. Basically, after approval of asylum is basically a form of permission to stay in this country. They don't need to get anything. Once asylum has been approved, then they have to apply. If the asylum has been approved, they're gonna give you 2.5 or 3 years. Then again, you need to apply extension. And after completion of 5 years, an individual will be eligible to apply for indefinite leave to remain. Asylum is basically a form of what it is called further leave to remain. So this category is specific, and on top of that, it's important for you to understand if the Home Office, in most of the cases, if the Home Office has refused the asylum application, the home and there are involvements of human rights. For instance, we had number of Libyan people who were in this conditions that instead of issuing or granting asylum, the Home Office granted them for the leave to remain on the basis of human rights, and they have been given permanent settled status nowadays. It's a long time ago when we had issues in Libya. So this is the whole background of asylum. I hope I explained you have understood it properly now, Tanzila.
Thank you,
Can we
sir.
move forward now? Okay, next is multiple entry. Uh, Article 3 of the order provides the entry clearance operates as leave to enter. And basically, the crux of multiple entry is this, that if an individual has been granted a visa or permission to stay, uh, or leave to remain in the country, it basically comes uh, with multiple entry permission. An individual can come and go before expiring of that permission. This is the whole crux of multiple entry. Then let's move to our stairs. Okay, when an individual is granted limited permission to enter or remain, that permission will be time restricted, and it will come with an expiry date. So when a vignette or biometric residence permit is issued, you're gonna normally see the date on it straight away on that one. So normally you're gonna see the expiry of visa uh, on the letter which you have received. Nowadays, all the visas are online or entry claims are online, so you're gonna get the expiry date on that visa. Uh, in past, the Home Office used to uh, uh, stamp up used to endorse a stamp or emboss a stamp on every passport, and we would normally say it vignette. So as I told you, there is a time limitation or expiry date on each visas. If the expiry date has been expired, then a person would be illegal in this country. And if the individual is illegal in this country, then there are repercussions. What are those repercussions? It will be quite difficult for that person to get further leave to remain, or if he or she applies for another visa. For instance, if an individual applied for visit visa and he or she stayed in this country after 6 months, and after expiry of 6 months, that individual left the country and returned back to his home country and reapplied again for a visit visa, then an individual gonna explain in detail why he or she stayed as an hour stay within the UK, and the Home Office can refuse it because that person basically breached the immigration condition and stayed as an hour stay in this country. So this is the whole crux of our stay. So let's move forward about second topic, which is making a valid application. So as I told you that in order to come in the UK, either to apply for entry clearance or for visa, you need to make a valid application. And valid application making is quite a complex process. We have a number of laws, we have guidelines, which I'm going to explain you with the passage of time. Let me add you further. We have, if you go, we have a web page which is called www.gov.uk. In order to get any information about the Home Office guidelines, we have specific guidelines on this web page about each visa category. As he already explained you, that we have different visa categories like visit visa. Then we have uh, 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 what it is called a visa for pleb. Then we have visit visa for the purpose of uh, attend the Lincoln's Inn um dinners. Then we have a visit visa for the purpose of medical purpose. Then we have innovator founding visa. So all these information you're gonna get from the Home Office web page, and the Home Office web page is has got number of guidelines. There are two type of guidelines you're gonna find on the Home Office web page. The first one is called guidelines for the caseworker, and the second one is called the guidelines for the applicant. It's always preferable for those people who work in immigration law category to read the guidelines which are for the caseworker, because a caseworker guideline is going to tell you what are parameters which a Home Office caseworker going to foresee in order to vet your application, and through that one you'll get an idea that how the caseworker going to assess my application, and you'll get better grip on your application. So this is the whole background how you're going to make a valid application. So let me further add, the application for leave to enter are always made from outside the UK, and application for leave to remain you would always apply from within the UK. So there are two things: leave to enter from outside the UK and leave to remain from within the UK. So this is the difference between both of the things. And on top of that, the Home Office guidelines, they normally change with the passage of time. And uh, apart from guidelines, as I told you, we have rules. Rules are basically that area. Rules are always made by the Parliament. And then we have the courts who are not bound, not for the guidelines, not for the rules. I'll explain you in details about the whole hierarchy of immigration law with the passage of time. Anyways, let me explain you a bit further about the whole hierarchy of immigration law. At this stage, if you have applied anti-clearance for the sake of arguments, if you have applied a visit visa, not for visit visa because there is no right for an appealing visit visa. If you have applied for skilled immigration program and the Home Office has refused it, and they have given you right of an appeal for the sake of arguments, then against the refusal of the Home Office, you'll straight away go and challenge the decision of the Home Office in a court. The first hierarchy of immigration law is called Tier 1 Immigration Tribunal. And against the Tier 1 Immigration Tribunal, then the second one hierarchy is called permission to apply for the upper tribunal. And once permission has been granted, then you're gonna go to the upper tribunal, and there we have High Court, and then after we have Supreme Court. This is the whole hierarchy of immigration law. In most of the cases do not go to the upper hierarchies, and in most of the time in immigration law cases they normally go up to the first tier tribunal. And on top of that, after passing this exam, can the question is, can you straight away go to the court and represent the client? Simple answer is no. If you have after level one, you have to go for level two and level three. Then you can appear and present the case to the tribunal. Or if you are a qualified solicitor, then straight away you can appear on behalf of your client. Or if you are a qualified barrister, then you can appear. We have another category in the UK which is called silex. If you are qualified with a silex, then again you can represent the case before the immigration tribunal. Immigration law is a very, very complex area, and it's a highly good area of practice, as in the UK, and you must have heard in the America even. On the basis of immigration, it's an immigration law and immigrants. We normally decide about the political future of these countries. So I'll suggest you focus on immigration law, and obviously with the passage of time, you're going to add further other professions or fields in your area. But if you are good in immigration law, then you can add on individual immigration, then you can further add on corporate immigration. Have passed your degrees, once you are in your profession or you are still already in profession, you can add on these further and further fields in your area for your future prospects. By learning these courses, by understanding these courses, you're going to enhance your future prospects in your future, not only within the UK. If you have a plan to continue your practice in the UK, then obviously you're going to open up the whole spectrum, or the whole profession within the UK. But if you are outside from the UK, obviously you're going to open up the whole new profession for you once you are, full-fledged, or once you have understood the whole complexities of UK immigration law. So let's move forward. And one thing I'd like to further add, that the Home Office is going to consider your application if the application is valid. If the application is not valid, the Home Office will not entertain the application, and they normally return your applications. So let's move forward. Entry clearance. As I told you, that applications for entry clearance, they are normally made from outside the UK. And historically, we had entry clearance on each and every station. For instance, if you are applying for entry clearance from Islamabad, so in past we had entry clearance officers who were sitting in Islamabad, Pakistan embassy, British embassy in Islamabad, and they would decide your applications while sitting there. However, now the process has been changed. Now you apply, basically it's the online, and they normally decide not on the embassies itself, but from within the UK. So this is the whole system which they have applied. This is the new regime, and in past we used to apply to the paper form, but nowadays we normally apply to the online. What does ECO stand for? And ECO stands for Entry Clearance Officer. Obviously, Home Office or the Secretary of State will not decide the application by themselves. They normally they have elevated their powers to their officers. Entry clearance officer is basically that person who exercise their powers while sitting while deciding the application, which are related to outside from the country. So when they decide within the country, then they normally use the word SSHD. It's important for you to write it down. SSHD. SSHD stand for Secretary of State for the Home Department, and ECO stand for Entry Clearance Officer. So this is the whole crux. So when you submit your application, you are required to upload your documents successfully, and you need to provide your fingerprints and photographs. In most of the countries, the Home Office is aligned with a number of other institutes. For instance, in Dubai, in Pakistan, or in Gulf states, the Home Office is in line or in alliance with Jerry FedEx. People normally submit the application online, and after submitting the application online, they go normally to the Jerry FedEx, and the Jerry FedEx people are responsible to take their photographs, to take their fingerprints, and in some of the cases, or you can purchase their different services. And if you don't want to upload the documents electronically, you can purchase your premium service, and through that premium service, they can upload your documents on the portal of the Home Office. So let's move forward to leave to remain. Uh, as I told you, that leave to remain we normally apply from uh, within the UK. So important issue when we apply to leave to remain is uh, important issue is timing. You must be yes, Wafa, you have raised hand. Any question? Wafa, you have raised any hand. Any
What is
question?
the role of SSHD?
Sorry.
SS, what is the role of SSHD?
What is
Role of SSHD.
SSHD? D for Delta, not B. But let me explain you. SSHD or Secretary of State for the Home Department. When you apply any application to the Home Office within the UK, Secretary of State for the Home Office is responsible to decide your application. Their caseworker decide your application. Normally, they decide as SSHD. When you apply from outside the UK, then the entry clearance office ECO normally decide your application. There is a difference. Apart from that, there's no difference at all. When you apply from outside the UK, entry clearance gonna decide it. When you apply from within the UK, then HSD gonna decide it. Even in the refusal letters or in their decision letter, they're gonna write it. SSHD has decided your application within the UK. So this is the main difference. I hope you understood it now. Okay, then let's move forward about lead treatment. As I told you, important thing before applying within the UK for leave treatment is the timing. As I told you before, the timing is very important. If an individual is overstay, then the Home Office can straight away refuse the application. And if a client leave has already expired, they'll be classed as overstay. In such cases, uh, that person who is at level one immigration, holding a level one certificate, or who has got a certification of level one, or who is qualified as a level one advisor, you have to refer that person who is overstayed to level two immigration advisor unless until you by yourself is qualified either level one, two, three, or you are qualified solicitor immigration, or you are registered with a SILEX. Then they're going to use Rule 39E. So I'll discuss what is Rule 39E for the time being, but not at this stage because it's too early to discuss Rule 39E. Okay, let's move forward to application timing. Okay, the requirement of making an application are set out in Rule 34 of the immigration rules. So can you write down with yourself Rule 39, 34 of the immigration rules? There were, as I told you, that in immigration law, uh, we have we have always amendments which we normally see, and we face amendments. For instance, uh, the recent amendments following significant amendment 2016, the rules now require that those applications which are made on after 24 November 2016, the applicant must be lawfully present in the UK at the date of application. So this is the example of a rule which I told you that they frequently change the rules and they frequently change the guidelines. So when you submit the application, as I told you, that you have to make a valid application. What is valid application? That application which you have submitted uh, before the expiry date of that application, right? In practice, an application is treated as submitted once you have submitted the home office fee, and within the UK, apart from the home office fee, you have to deposit immigration health surcharge as well. Immigration health surcharge is basically a charge which you normally pay to the home office for the purpose of using the health facilities. So this is called immigration health surcharge. In different countries, we have different name. For instance, people who go to the United States of America, they normally purchase insurance. As far as I know, I'm not expert, I have no knowledge at all about US immigration law, but I'm just comparing it. In UK, these people normally purchase immigration health surcharge. For instance, if a person is within the UK and that person is on skilled immigration program, and that skilled immigration program visa was valid for 2 or 3 years, and once he or she gonna apply for further leave to remain, he or she gonna apply two fees. First is called the home office fee, and the second one is called immigration health surcharge. Immigration health surcharge for 1 year is about 40 to 1,500 pounds. I'm not quite sure at this stage. Okay, let's move forward. About applying after leave expire. As I told you that you must have to apply before the expiry of your visa. If you are applying after expiring of the visa, then what's going to happen? In certain circumstances, you can apply uh, after expiry of visa. What are those circumstances? I'll explain you later on. At this stage, I'll explain you a very, very important concept, which is called Section 3C of the Immigration Act 1971. Can you please note down Section 3C? Section 3C is very, very important because when you appear in immigration level 1 immigration advisor authority exam, they definitely ask question, either scenario-based question or uh, any MCQs about Section 3C. Can you write down with yourself Section 3C of the Immigration Act 1971? Can you please confirm if you have written down with yourself about Section 3C of the Immigration Act 1971?
Yes, sir.
Wafa, Shanza, have you written Section 3C? Okay, what is Section 3C? Basically, I'll give you an example, then I'll take you through Section 3C because in our previous lecture, Section 3C was a bit confused for some people and they have posed lots of questions from me. So I'll quote an example, then we're going to read Section 3C, and this is how you're going to understand Section 3C more properly, okay? Let's move forward to Section 3C example. If an individual is in the UK, an individual was on a skilled immigration program. That visa was valid for 2.5 years. And before expiry of that visa, he applied his extension within the UK. And his visa was expired when his application was pending with the Home Office, right? Then Section 3C would jump in order to give protection of that person to become our stayer. So this is the whole crux of Section 3C. In order to give protection of becoming our stayer when the application was pending with the Home Office, we have Section 3C of the Immigration Act 1971. Obviously, Home Office is going to take weeks, months, and sometimes even number of months to decide the application. The Home Office will not decide your application within few days. So in order to give you protection not to become our stayer, we have Section 3C. So let's read now what is Section 3C in detail in order to make you better understand. The purpose of Section 3C is to ensure that a person who submits an in-time application to extend or vary leave does not become an hour stay while awaiting a decision, including during any period in which an appeal or administrative review is pending. One thing more, no on application. If an individual application was decided and thereafter, after rejection, an individual has filed an appeal or administrative review, then we have still the protection of Section 3C. So Section 3C would not only cover the pendency of application, it's gonna cover administrative review pendency and plus appeal pendency. Then let's move forward when Section 3C applies. A person leave will be extended under Section 3C where they hold limited leave to enter or remain in the UK. They make an application to the Secretary of State to vary that leave. The application is submitted before the existing leave expires. Their leave expires before a decision is made on the application and the application has not been decided or withdrawn. So I hope you understood and you have read with me about when Section 3C applies. So one more important thing is that Section 3 leave is not formally confirmed by the Home Office. So it's very important for you to understand. Then on top of that, we need to understand uh, that an application, in order to get the protection of Section 3C, an application must be submitted before the leave expires. If you are submitting an application, there are certain categories when you can apply after the leave has expired. As I'm going to explain you further. If you are applying after expiry of your visa, then you are putting the whole ball in the court of on the Home Office. Either the Home Office gonna accept your excuse, or not only excuse the reasons why you did not apply well on time or not. If they have accepted it, then yes, we'll have a continuity of Section 3C. If they have rejected your application, you will not have protection of Section 3C. Let's move forward. Valid and invalid application. Any questions so far, please? Shanza, Zuma, Wafa,
No, no question.
no question at all. Okay, we'll have a bit chit chat. I'll give you ample time duration to raise any question about any topic, but not at this stage. Let me finish this whole syllabus today because we have a few topics remaining. Are you feeling a bit bored or you are okay now so far? Hello?
Yes, sir,
Uh,
it's okay.
wonderful, wonderful. Shanza, are you okay?
Yes, sir, I am okay.
Wonderful. For a reason I'm asking these people if so I'll make it sure they're not sleeping. They are with me. I hope so. All of you are with me, but just I'm kidding with you. Okay, valid and invalid application. It's essential that application is valid. What is valid application? I'll discuss you later on, but it's very important for you uh, to make it sure that your application is valid. If your application is not valid, the Home Office is going to reject application. And if you have submitted invalid application, you'll not have a right of an appeal, administrative review, and you'll not be given or you'll not have a protection of Section 3C. So make it sure that you always submit valid application. And in practice, what normally happens if you submit an application and that application is not valid for the sake of arguments, if you have submitted to the Home Office and there's an issue with the fee, the Home Office will give you ample time duration to submit an appropriate fee, and they normally ask you before rejecting it, because this is a part of procedure that you should be given an opportunity to correct that error which has been made in the application. So make it sure to submit a valid application if you have submitted invalid application, and the individual or your client has become an overstay, it will be a big issue, and your client or you by yourself will not have a protection of Section 3C. So it's important for you to understand the difference between valid application, invalid application, and if the Home Office has rejected the application, then you'll not have protection of Section 3C. They'll not give you right of an appeal. You won't be able to file an appeal at any stage at all. Then obviously you'll have the other opportunities available. For instance, you can state of a check the Home Office through uh, patient protocol notice, or it's a quite complex area. So it's important for you to submit a valid application before expiry. So let's move forward. What is our staying? We discussed previously if an individual has stayed in this country after the visa or after the date which was endorsed on the entry clearance, that person will become our stayer. However, there are exceptions when you can apply after expiry of your visa. What are those exceptions? I'm going to tell you now. Basically, paragraph 39 of the immigration rules set out limited exceptions for our stayers. Can you please write down with yourself paragraph 39E of the immigration rules? It's very important for immigration advisor authority exams, for your practice point of view, for every point of view. It's important for you to write down with yourself paragraph 39E of the immigration rules. Can you please let me know if you have written on your notebook about paragraph 39E of the immigration rules?
Yes, sir.
Okay. As I told you that you have to apply for the leave to remain or your extension within the time duration. However, there are certain exceptions. What are those exceptions? They have been explained in 39E. And these 39E rules are divided into three parts: 39E1, 39E2, 39E3. However, level 1 advisor are restricted to relying on paragraph 39E. So, apart from 39E, we'll not discuss any other areas because today we are focusing just for level 1 immigration advisor authority exams and their whole syllabus. So, what are those exceptions? Exceptions are that you have to submit an application after 14 days, and if you have a good reason why you did not submit your application before the expiry of your visa. For instance, if you are representing your client and that individual was not well, and that individual was on a bed, he or she cannot apply before the expiry of your visa, then you can apply straight away after 14 days, and you can explain the Home Office along with the evidences that look, this person was on a bed, he was not well. This is the whole proof in terms of NHS documents, in terms of your GP letter, and the Home Office. There are highly chances the Home Office going to accept your reasons. However, the balance of probability is always on the applicant. It's always on you to satisfy the Home Office that why you did not explain, you did not apply well on time and before the expiry of your visa. So as I told you that you have to apply within time. If you don't apply within time, then you can straight away go and get the protection, get a leverage under paragraph 39E. However, it's very important for you to understand that if you have not applied within the time duration, and then it's up to the Home Office to accept your reasons of not applying. If they have accepted your application, then obviously you'll have Section 3C, and there will be an application of Section 3C. If they have not accepted your reasons of not applying within time duration, then you'll become our stayer, or your client will become our stayer. So do not put yourself in a vulnerable situation to yourself or your client. And obviously, you are putting the whole situation in the Home Office, in the Home Office side. and you can put yourself, in a misery and in a hostile environment with your client. And if you have not applied within time, uh, it's very important to inform your client if your client has applied after the expiry of the visa, about the whole outcome, about section paragraph 39E of the immigration rules. So let's move forward. Fees and exemption. I hope all of you have understood what is paragraph 39E of the immigration rules, fee and exemption. When we apply for any category of application, the Home Office, we are required to pay the Home Office fee plus the immigration health surcharge. However, there are certain categories where we can apply for the exemption. And if what are those categories? If there is involvement of breach of human rights, then we can apply for exemptions and fee waiver, and the Home Office can give fee waiver about the immigration health surcharge and the main application. However, we need to satisfy the Home Office why we can't apply in most of the cases when we apply fee waiver within the UK. We normally inform the Home Office that the involvement of human rights, this individual cannot afford, and if he or she has paid the fee of the Home Office, there are highly chances they'll become destitute, and there is an issue about the affordability test. They cannot apply. However, you need to provide the whole details about the affordability. In most of the cases, you have to provide your bank statements along with the application of not paying or for exemptions of the Home Office fee. And not in all of the applications you will pay the immigration health surcharge. Those applications which are for more than 6 months, you have to pay the immigration health surcharge. Uh, uh, since you don't need to pay the immigration health surcharge. So this was the whole uh, brief explanation of fee and exemptions. So let's move forward to next topic, which is any questions so far? Shanza,
I
Wafa,
have a question
Zuma.
I'll ask at the end
Yes,
of the
Two
Wafa,
session.
go ahead.
questions.
One by one, please. Who is there, please? Wafa, it's your turn. You can pose a question, please.
So I could not fully grasp Rule 34.
Rule
34.
34 we discussed previously. Recently we discussed 39,
Yes,
39E.
sir. So
So
I haven't understood 39.
recently we discussed 39E, Wafa. If you still have a question about Rule 34, I can explain you later on. Is that okay for you? Because we are moving forward. When I had given you an opportunity or you missed the opportunity, obviously I'll take your question, but not at this stage about Rule 34. We discussed about recently about Rule 39E before fee and exemptions.
Right, sir.
Are we on the same page now? Can you explain you Rule 34 later on, please? Is that okay for you?
Yes, sir.
Okay, any question from anyone? Or we can move forward. Okay, let's move forward to preparing an application. It's very important for you as a qualified person to prepare a very valid application. What is valid application? Valid application means that application where you have you have completed the whole application properly. You have provided all documents, the Home Office. You have paid immigration health surcharge. You have paid the fee, proper fee to the Home Office. This is called valid application. However, each case depends heavily on the individual circumstances. Basically, I always uh, ask the immigration advisors or those people who work in the profession that do not follow the standard list of the documents. Always make a list of documents according to the circumstances of individual. Thereafter, you can make a valid application. Because the Home Office has given list of documents, that list of documents, according to my point of view, does not cover the whole circumstances or according to the circumstance of individual. So the best practice is if you are with a client face to face, make your own notes. If you are with a client online, again, you make your notes. And after making your notes, prepare your own list of documents. Thereafter, that list gonna lead you toward the success. And on top of that, it's very important for you to, when you apply for any application, I have seen that people normally, give information on the phone. What they normally do, they normally give a call straight away. For instance, if we are applying visit visa for the client, after booking the client, they normally pick up the phone and they start completing the application whilst they're on the phone. It's really a bad practice. Now we do it. How you gonna do it very properly? Just start preparing the application, make further documents list, post any question, all the question in a written form. And once you have all the questions printed, put in front of you and start completing the application. This is a professional way. What is the other way around? The other way around is if your law firm has a recording system, then record each and every question, whatever the answer has been uh, posed and whatever the answer the client has given it to you in order to cover your backup. Let me explain you further why I'm asking you this whole situation. Because for the sake of arguments, you have applied a visit visa from Pakistan, India, Bangladesh, or from any other country. And you have posed a question from the client, have you ever applied any visa before? And the client said no, but in practically the client had applied and that visa was refused, and you have not provided the proper information to the Home Office. And if the Home Office has found, then yes, you applied a visa before. It means you have hidden a material information to the Home Office. The Home Office is going to refuse the application. The Home Office going to ban the individual from the 10-year under Section 320C. That will be a 10 years ban on the application of your client. The client straight away gonna come in your office and he gonna bang on your head. The client would say, look, I never told you. In that situation, you can straight away pick up your notes, whatever the question, whatever the answer the client had given you, or you can straight away switch on your recording and you can say to your client that, look, this is the answer which you had given. One thing more, if your law firm has a system in place to record every conversation of client, it's very important for you to inform your client that we are recording this conversation for the purpose of training purpose and for the purpose of our usage. We have a data protection act in place within the UK. You are not allowed to record any conversation without in advance approval and in advance permission from your client. So make it sure that you have informed to the other party that you are recording their data. You cannot record their data without their permission. It's very important for you. We have Data Protection Act within the UK. If you are recording something without the consent of your client or without the consent of any third party, you are straight away breaching Immigration Data Protection Act within the UK. I hope you understood that. Uh, I hope you understood the whole crux of valid application. Okay, let's move forward. An advisor further must be able to interpret and apply the immigration rules very correctly, and they should know that how to apply the facts of the case, and they should identify and gather appropriate evidence to demonstrate the application meets the requirements. And it's important to provide the evidences properly, and they must be capable of granted of providing the to apply the exact rules according to the circumstances of individuals. When you normally apply an application at the Home Office, normally pose a question in a very simple language, but the repercussions are very serious. Uh, if you have come across any application, you'll see that they normally pose in a very simple plain language, but the repercussions are very serious. So make it sure whenever you start application, any application, even visit application, further leave to remain, extensions, appeals, anything, make it sure you should know the immigration rules. You should know the guidelines. You should know what is the procedure. It's very important for you because the questions are in a simple mode, yes and no, but the repercussions are very serious. So do not put yourself in a miserable situation. Do not put your clients, in a miserable situation without knowing or without a grip of the whole of immigration law. It's very important for you to know the in-depth knowledge about the whole system before starting this practice. Because uh, if without knowing, without qualifying, you have started this practice, then it's an offense within the UK, and it's a criminal offense, and you can face regulatory, repercussions. You can face even the criminal offenses if you're not qualified and you have made a professional mistake. So be careful before doing any immigration law practice. So this is the whole, about preparing a valid application. Then let's about conclusion. So far, we have discussed the core principle governing leave to enter and leave to remain in the UK. Then we discussed about the procedure required to make valid application. And then we discussed the structure of immigration law. And then we discussed about the fee, about the asylum applications, and what is our stay. Then we discuss if a person has become our stay, if there is any way out in order to apply that application. I told you about the relevant rule. So this is the whole conclusion. Any questions so far related to today's session? Once we have done the relevant question, then I'll give you an opportunity to raise any question related to the immigration law, anything. I'll be happy to take any question. So, any question so far about specifically about the topic which we have discussed so far? Any question, please?
So, who could be the representative of the client for applying the application? Is that
Okay,
a person himself or it could be someone else?
let me explain, Wafa. Uh, the application you can do, or individual can do application by him or herself, or the way you can appear before the court in person. In a very same way, an individual can do the application by him or herself, or an individual can hire a person, and that person will be representative. Who can be representative? In the UK, a person who is a qualified person as an immigration level one advisor, that can be representative. The person who is a qualified barrister, that can be representative. Qualified barrister can be representative. Or, as I told you, there's another body, regulatory body within the UK, which is called Silex. They can represent the client on their behalf. So they can represent the client on their behalf. Apart from that, there's no other category. And if you are from outside the UK, for instance, you're in Pakistan, Bangladesh, or UAE or any part of the country, then you must be qualified within your own regulatory body. For instance, you're in Pakistan, you must be qualified with your local body like Islamabad Bar Council or Pakistan Bar Council or Islamabad Bar or any other local body as an advocate. I understand that there is no restriction at all in some countries to do the immigration law practice if you are qualified or not. There are lots of people, who do immigration law who advise, but practically, ethically, that is not allowed. It's a bad practice. And I'm quite positive within passage of time that practice is going to end because those people are involved in lots of ethical issues and immoral issues. Obviously, a person who's qualified, who's a qualified immigration advisor or qualified a lawyer, before doing anything illegal, obviously, or immoral, obviously, they're qualified people. They are trained to do their job. Obviously, this practice is gonna stop with the passage of time, and we all qualified people are hopeful that this back door gonna close with the passage of time. But within the UK, there is no concept at all to provide any immigration advice. It's a criminal offense within the UK. Apart from the UK, obviously, the UK law has no applicability across the borders. But within the UK, yes, we have a strict regime. You cannot represent your client unless until you are qualified. I hope I explained you far about your question.
Yes, sir. And sir, you told us that you have to follow certain levels, like level, firstly the home office, then there are other levels, up levels, and then you go to high court
Level
and
one,
supreme court.
level two, level three were far.
Yes, sir. So if a person applies himself, then he has to go through all the levels. But if
No,
there is a barrister, he can directly go to high court or tribunal. This is
let me
what you
explain
said.
you. Wafa, can you please? I could not understand your whole question. Can you explain your question in a bit brief way? I would understand your question, please.
Maybe I misunderstood. You told us about the levels you have to
Mm-hmm.
follow
Mm-hmm.
for a valid application.
Not
That
application, not, let me explain. Okay. You explain your question, then I'll answer you. You complete your question at this stage, please.
according to my understanding, maybe you said that if you apply yourself, you have to follow the levels. But if there is a barrister or a silent, then he can directly go to the court or higher levels.
Let me explain you, Wafa. Level is for the purpose of that client who gonna come to you, right? As far as concerned about individual who is applying by himself, then obviously you have no responsibility of that person. He or she shall be responsible by himself because he is applying by himself. But level one, level two, level three, basically these are levels within the immigration, which has been categorization of immigration advice authority advisors. For instance, if an individual is qualified up to the level one, then that person cannot do complex cases. That person can do just the basic cases, for instance, the basic applications. If that individual wanted to, that advisor wanted to represent the case before the tribunal or he wanted to do the appeals, then he or she has to enhance his or her qualification because his qualification was limited up to the level one. However, If a person is a barrister, solicitor, or qualified with the silex, then they are completely exempt to do their registration with Immigration Advice Authority. They are completely exempt. They are not required to register themselves at any level, level one, level two, level three. They are completely exempt. They can straight away go to any court. They can represent at any stage. They can do whatever practice they can do. And on top of that, one thing is important. Uh, Level one solicitors, barristers, and silex regulated people, they they can do any practice, not only immigration practice. They can do family law practice, civil litigation, criminal law practice according to their own area of practice. But as far as concerned about level one, level two, or level three immigration advisors, or those people who are qualified or regulated with Immigration Advice Authority, they can do just the immigration law practice up to the extent of their qualified level. I hope I understood. I hope I explained your question.
Yes, sir. Thank you so much.
No problem. I'll explain you how, with the passage of time, I'll raise, uh, your professional capacity, and we'll have a session about separate session, how to become a barrister, how to become solicitor, and what options an individual will have after passing LLB within your country and outside from the country. I hope these type of sessions are very, very important because I've noticed that after completion of LLB, students normally, do not know what options are available, and they waste lots of their time just to dig out where they can launch themselves, once they have completed their law degree. I think these sessions are important for us to arrange and to continue at university level. What do you think? Hello, Wafa, are you with me? Anyways, any further question if you can hear from me?
Sir Shanza here. I have
Yes,
a
Shanza, go.
question.
Yeah, Shanza, go
Before,
ahead.
yes, sir, we will discuss before a visit visa. Someone
Hmm.
questioned and you answer. Maybe I misunderstood. If the visit visa is for 5 years, do
Hmm.
individual have to come back or return to his home country after every 6 months, or he can
Within
come back?
within
Yes,
six
sir.
months.
Uh, okay, sir. I
Within
I
6 months. Within 6 months. For instance, if your client has got a visa for 6 months, right? And that visa was a visit visa, then he or she cannot stay beyond 6 months. They are required to come back within 6 months. However, they can go again after 6 months. And Shanza, one thing is more, visit visa cannot, on the basis of visit visa, an individual is not required to do a job in the UK
yes, sir.
because they are not allowed to do the job. However, in certain categories, they can provide certain, you can do certain activities which you can find the home office. For instance, uh, if you if you want to give any advice to your client who is based in the UK and they have got some property issues back to home country, then you can come in this country for the purpose of advising, and you can inform the home office that, look, I need a visit visa for the purpose of advising to the client. And yes, this is an activity which you can do. There are some activities, but there are very, very limited activities. Not as a full-fledged banquet, you're allowed to do the work. You are not allowed to do the work on visit visa. I hope I have answered your question, Sean.
Understood, sir. Understood.
Any further question? Okay, now let's move a bit informal discussion. What do you think? How was this session? It was quite difficult for all of you to digest, or you have digested something, and with the passage of thing, obviously with the passage of time, I'm quite positive if you stuck with me after 2 months, then you'll be fine to appear even, in level one immigration advisor authority. Obviously, we're gonna give you a certificate course, and after this 2 months certificate course, I'm quite positive you will be in a position to apply jobs, for basic jobs, uh, even part-time online in a, you'll be able to stay away, sit your level one immigration advisor authority exams. Uh, this 2 months course gonna open up your lots of doors. Uh, I'm quite positive, you'll be fine with the passage of time. So, what is your point of view? Have you understood something, or it was quite difficult for you to digest whatever I have taught you in today's date?
The session was wonderful, but as we are in Pakistan and we rely on Wi-Fi, so that interrupts
No
us
problem,
too much.
Wafa. No problem at all. Let me explain you. We're gonna upload this whole video on our YouTube channel. And on top of that, we're going to provide you soft copy of this whole lecture. Uh, I'll ask you, please like and subscribe our YouTube channel, because with the passage of time, for public and for you guys, we're going to upload lots of videos and lots of lectures. They're going to be helpful not only for immigration law category. As I told you, we provide training for to become solicitors, to become barristers, and on top of that, we're going to provide training or certificate course related to corporate law. We're going to provide training related to white collar crimes, money laundering. Uh, we have a number of certificate courses. They'll be really helpful for all of you. I hope so. Uh, can you hear all of me? I'd like to, discuss a bit something apart from this whole course. You know, uh, what is the crux that how we understand and how long we're going to take to understand something, and after spending how many hours we need, and after spending how many months or time duration, we understand the things properly. Just remember when you started your first class in LLB. If you still remember when you started your first class, which was LLB, do you still remember? Wafa, can you hear me? Shanza, if you still remember
Yes,
when you
ma'am.
were, okay, Yumna, if you still remember when you were in your first lecture of LLB, just remember and just, you know, refresh your memory. It was really difficult time for you. Obviously, the teachers were highly qualified, terminology was new, and, you were up to your head. You decided it's so difficult for me. But then your parents told you no. Your colleagues told you no, stick with it. With the passage of time, the things will be easier. So same situation is here. It's your first lecture. Things are quite difficult for you. I can understand. But I can give you guarantee that things will be easier with the passage of time. The only ultimate solution is stick with this, understand it, and with the passage of time, you'll be fine. You know, what is definition of success? Have you ever heard about it? How we get success? If someone can tell me, although it's not a part of this session, what is definition of success? How we get success in our life? Have you ever uh, read those people who were successful in their life? There are lots of people who are successful in their life. Take, Shahid Khan from US in the billionaires list, Nelson Mandela, Qaid Azam. There are lots of heroes, in life. There are lots of books, being written on the success stories. What was common in all of them? Did you ever think about yourself? Did you ever discuss with yourself what was common if they were extra genius? Yes, they were genius, but not all of them. One thing was very common in all of them, and that was consistent effort on slow basis, on continuous basis. And the second thing was they were very, very punctual on their efforts. If you have not studied the whole of year, whole semester, and you have started your preparation 2 or 3 days ago, no matter up to what extent you are genius, you cannot compete that person who started the preparation from the day first and who was punctual. You cannot compete. It's against the law of nature if you have competed, that person who stayed the whole semester and you've started 2 or 3 days ago. So be constant, trust on you and trust on God, then you're gonna get success end of the day. Be constant, be constant, be constant. There is no second way out. There is no shortcut. The only shortcut is be constant. You should know what is your target. If you know what is your target, if you are confused, obviously, you know, if you are confused, obviously, you can't get success in your life because you by yourself is confused. And on top of that, sometime I discuss with my clients, I do lectures up to LLM level. I have different, I do deliver lectures to immigration advisors, to barristers and solicitors. In our life, if we go left or right, it's so difficult for us to decide which one way was better, either left or right. There was no way better. The left or right, whatever you have taken the turn and you were constant on that turn, that one way was better. This is the whole underlying crux. Anyways, nice to speak with all of you. I hope all of you are a bit relaxed, and I hope you have understood something from us now. We're going to provide lectures in a soft form. We're going to upload this lecture. Our IT team going to take some days in order to upload this lecture on our YouTube channel. And I hope all of you are fine. Any further question? If there's no further question, I think it's over now because time is nearly 3 o'clock. We have spent about, a number of hours just to finish this lecture. Can we finish it now?
Yes, sir.
Wafa? Okay then. Okay, and thank you for your participation. Okay, thank you to all of you, and bye-bye, dear.